Welcome to the deep dive. We're here to help you make sense of the really critical legal shifts happening right now.
Absolutely.
And wow, the Supreme Court term just wrapped up, end of June 2025, with some huge decisions. We're talking June 27th, June 28th. Just boom, boom, boom.
It was quite a finale. These rulings are definitely set to reshape, well, quite a lot about American law and the balance of power.
Exactly. So today we're diving deep. We've got a stack of sources, legal analysis, historical stuff, news reports, and we're going to distill it all. We want to unpack these key cases, look at the history, the judicial philosophies driving them, figure out what it all means for us.
And there's a lot to unpack. It goes beyond just single cases. It's about seeing the bigger picture, the direction the court might be heading.
Right, getting a handle on these rules for the ages, as Chief Justice Roberts put it in one context. So let's start with the philosophy. There's this idea of judicial restraint making a comeback. How are you seeing that play out?
Well, judicial restraint, at its core, it's about courts being cautious, showing deference, right?
Deference to Congress, to past decisions.
Exactly. Deference to the legislature, sticking to precedent stare decisis, and generally taking a narrow approach, avoiding big constitutional questions if they can. It's sort of the opposite of judicial activism.
Okay. And we've seen historical figures champion this, like Holmes, Frankfurter, Rehnquist, too.
Definitely. Justice Frankfurter was almost the model of it. And Chief Justice Rehnquist also leaned that way. It's a philosophy with deep roots.
That makes me think of Justice Brandeis and his Ashwander rules from back in the 30s. Those seem directly relevant here, don't they?
Oh, absolutely.
Yeah.
The Ashwander rules are like the practical playbook for judicial self-restraint.
Can you remind us of the key ones?
Sure. Things like the court won't decide a constitutional issue if the case can be settled on other grounds.
Like just interpreting a statute.
Right. Or don't anticipate constitutional questions before you absolutely have to.
Yeah.
Don't make rules broader than the specific facts of the case demand.
So really trying to steer clear of those big constitutional rulings unless there's no other choice.
Precisely. It's about keeping the court out of the political thicket, pushing things back to the elected branches.
It's interesting because, critics might see some recent Roberts Court decisions as overreach, but the proponents often frame them using this very language restraint, limiting judicial power, deferring.
It's definitely part of the framing, which makes digging into the specifics of the rulings even more important. How is this philosophy actually being applied?
Okay, let's do that. Let's get into how these rulings are reshaping checks and balances. Executive power, judicial oversight. Where do we start?
A really big one was the ruling on nationwide injunctions. That came down June 27th.
Ah, yes, the 6-3 decision limiting those. Remind us what nationwide injunctions are again.
So these are orders from a single federal judge that can block an executive branch action, like a new regulation or policy, across the entire country, not just for the people suing.
And the court said judges generally shouldn't do that anymore, just relief for the parties in the case.
That's the gist of it, yeah. Relief should typically be limited to the specific parties involved.
Okay, from one perspective, that sounds like it strengthens the president's hand, makes it easier to implement policies without one judge stopping everything.
It's definitely seen by some as a win for executive discretion, curbing what they saw as judicial overreach and forum shopping, where plaintiffs look for a sympathetic judge.
But the dissent was really strong. Justice Jackson called it an existential threat to the rule of law, said the executive could violate the Constitution for anyone who hasn't sued yet. Justice Sotomayor, too.
Right, and that highlights the fundamental disagreement. Is this restoring balance by stopping single judges from setting national policy? Or is it removing a vital check on potential executive overreach, leaving people unprotected?
Two very different views on the role of the courts there.
Very different. It goes to the heart of how judicial review should work.
Okay, sticking with courts and the executive branch.
Sure.
Let's talk about Chevron deference. That was another huge one, overturned June 28th.
Huge is right. Chevron deference, for decades, meant courts generally had to defer to how federal agencies interpreted ambiguous laws Congress asked them to administer, as long as the interpretation was reasonable.
And now, that's gone.
Gone. The 6-3 ruling, written by the Chief Justice, basically says courts now have to decide the legal questions themselves, using their own judgment. No more deferring to the agency's view just because it's reasonable.
Justice Kagan predicted a massive shock to the legal system, called it a judicial power grab.
She did. Her dissent was forceful. She argued it shifts enormous power over complex regulations, environment, finance, health, from expert agencies to, well, generalist judges.
So a major power shift from the executive agencies to the judiciary.
Undeniably. It's seen by supporters as restoring the judiciary's proper role in interpreting law, but critics see it as undermining the effectiveness and expertise of the administrative state.
And this wasn't the only hit on agency power, was it? There was the SEC v. Darkisy case, too.
Correct. Also on June 28th, the court said the SEC can't use its own in-house judges without juries to impose fines in certain fraud cases. That has implications for lots of agencies that use similar internal processes.
And the EPA case, Ohio v. EPA.
Right, June 27th. The court put a hold on an EPA clean air rule, the good neighbor provision. It signals much tighter scrutiny of significant agency regulations before they even take full effect.
So when you put those together, overturning Chevron, the Darkisy decision, the EPA ruling, it looks like a very clear trend.
It does. It aligns with a long-standing goal in conservative legal circles to rein in the power of federal agencies, arguing they've become an unaccountable fourth branch of government. The court is definitely asserting more judicial control over the administrative state.
Okay, so agencies are being reined in. What about the presidency itself? Let's talk Trump v. United States and presidential immunity. That was back in July 2024, but its impact is still huge.
Absolutely pivotal. The 6-3 ruling established that former presidents generally have immunity from criminal prosecution for their official acts taken while in office.
Which makes prosecuting former President Trump for things related to January 6th much harder, potentially delaying trials indefinitely.
Significantly harder. The court sent the case back down to determine which acts were official versus purely private. Chief Justice Roberts wrote about needing a farsighted rule, one for the ages, to protect future presidents from politically motivated prosecutions after they leave office.
But again, powerful dissents. Justice Sotomayor warned it risks making the president a king above the law. Justice Jackson called it a five-alarm fire.
It's that fundamental tension again, protecting the presidency as an institution versus ensuring accountability, even for a former president. The majority prioritized institutional protection, fearing a cycle of retribution. The dissenters prioritized accountability, fearing impunity.
And earlier in the term, the court also dealt with the effort to disqualify Trump from the ballot under the 14th Amendment. That was unanimous, right?
Unanimous in result, yes. They ruled Colorado couldn't disqualify him. The majority reasoned that Section 3 of the 14th Amendment requires action by Congress, not individual states, to enforce it against federal candidates.
I remember Justice Barrett's concurrence there. She urged the court to turn the national temperature down.
Right, a call for judicial restraint in a highly polarized moment, suggesting the court shouldn't be adding fuel to the political fire. Let Congress handle it.
And one more related to January 6th, the Fisher case on June 28th.
Fisher v. United States, yes. Another 6-3 decision. It narrowed the scope of a federal obstruction statute used against many January 6 defendants, including potentially Trump.
How so?
The court said the law primarily targets actions related to tampering with evidence. Prosecutors now need to show that connection, which could make convictions under that specific law more difficult for conduct that didn't directly involve evidence impairment.
Okay, so big shifts in executive power, agency authority, presidential accountability. Let's pivot now to what are often called the culture war issues, individual liberties. Where did the court land this term?
There were several significant rulings. One was Mahmoud v. Taylor on June 27th.
Right, the case about parents opting kids out of lessons with LGBTQ plus themes in public schools.
Exactly. A 6-3 decision held that parents can opt their children out if the lessons conflict with their sincere religious beliefs. Justice Alito's majority opinion focused heavily on protecting religious exercise under the First Amendment.
And Justice Sotomayor dissented, warning about floodgates.
Yes, she worried it could lead to parents demanding opt-outs for all sorts of subjects, science, history, potentially disrupting public education and undermining common curricula. It really pits religious freedom against the goals of inclusive public schooling.
Also on June 27th, the court allowed Texas to require age verification for accessing pornographic websites.
Correct. That was framed by supporters as a win for protecting children and empowering parents and states to regulate online content deemed harmful to minors.
It seems like a pattern there, emphasizing parental rights and state authority in these sensitive areas.
There's definitely a theme of deferring to parental authority and state legislative judgments on moral or safety issues concerning children.
Okay, what about abortion? Always a major focus. The court heard a couple of cases this term.
It did, but it didn't make sweeping new rulings on abortion access itself. Remember, Dobbs in 2022 overturned Roe v. Wade, sending the issue back to the states.
Right, creating that patchwork of laws across the country.
So this term, on June 13th, the court dismissed a challenge to the abortion pill mifepristone. It said the doctors and groups suing didn't have the legal right, the standing to bring the case. So access wasn't restricted by that ruling.
Okay, so a procedural dismissal and the Idaho case.
That one, decided June 27th, involved a conflict between Idaho's very strict abortion ban and a federal law called EMTALA, which requires hospitals to provide stabilizing emergency care. The court essentially punted, allowing emergency abortions in Idaho to continue for now while the lower courts sorted out further. No final decision on the merits yet.
So the post-Dobbs legal battles continue, but no major shifts from the court this term on the core issue.
Not on the core right, mostly dealing with the fallout and specific applications.
Got it. Let's talk Second Amendment, gun rights, the Rahimi case on June 28th.
United States v. Rahimi. This is really important. An 8-justice majority upheld a federal law that prevents people subject to domestic violence restraining orders from having guns.
That sounds significant, especially after the Bruin decision emphasized historical tradition. How did they square that?
Chief Justice Roberts, writing for the majority, clarified how to apply Bruin's history and tradition test. He said the government doesn't need to find an exact historical twin for a modern gun law. Instead, courts should look for historical laws that are relevantly similar in principle.
And they found a tradition of disarming people deemed dangerous.
Yes, the court found that historical laws did disarm individuals considered dangerous, and the domestic violence restraining order law fit within that tradition. So it upheld the law while still applying the Bruin framework.
Interesting. And while that's the federal level, we know gun rights are a huge focus in states, too.
Absolutely. State legislatures and advocacy groups are constantly active. We see things like changes to open carry laws, adjustments to concealed carry permit fees, often driven by grassroots efforts.
Like the Virginia Citizens Defense League you mentioned.
Exactly. Groups like VCDL push for specific changes at the state and local level, really embodying that idea of walking the walk, focusing on concrete policy changes based on their interpretation of the Second Amendment.
Okay, one more in this bucket. Homelessness. The Grants Pass decision?
Grants Pass v. Johnson. The court upheld local ordinances that banned homeless individuals from using things like blankets or sleeping bags on public property.
Justice Gorsuch wrote that homelessness policy isn't for federal judges to dictate, right? It belongs with local governments.
That was the majority view. It's a complex social issue for the democratic process, not the courts, to solve. But Justice Sotomayor's dissent was scathing. She argued it essentially criminalizes being homeless for people with nowhere else to go.
A really tough issue with starkly different perspectives on the role of law.
Definitely. It raises fundamental questions about punishment, necessity, and how society addresses homelessness.
This actually leads us nicely into our final area. With all these shifts at the federal level, what about the role of state constitutions? You hear them called laboratories of democracy.
That's a crucial point. We often focus intensely on the U.S. Supreme Court, but we actually have effectively 51 constitutions in this country, the federal one, plus one for each state.
And each state constitution has its own Bill of Rights.
Exactly. And state courts interpreting those state constitutions can, and often do, provide more protection for individual rights than the federal constitution requires. It gives people, as some scholars say, 2 free throws, a chance to argue for rights under both federal and state law.
Constitutional pluralism.
Right, that's the term. And it's not just theoretical. State courts have often led the way.
How so? Where do we see state constitutions offering broader protections?
Well, take unenumerated rights, rights not explicitly listed. Some state courts are more willing to recognize things like right to earn a living, striking down occupational licensing laws, for example, under their state constitutions.
Like that Georgia case about lactation consultants.
Precisely. Also, search and seizure. Many state Supreme Courts offer greater privacy protections under their own constitutions than the Fourth Amendment provides.
Rejecting federal rules like a drug dog sniff isn't a search.
Yeah, or the open fields doctrine that says police don't need a warrant for undeveloped private land. States like Minnesota, Montana, Oregon, Pennsylvania, others, they've said their state constitutions require more protection for private property or against dog sniffs.
That's fascinating. What about suing the government?
Some states make it easier. Federal law has doctrines like sovereign immunity and qualified immunity that often shield governments and officials. But states like Nevada or Michigan have interpreted their constitutions to provide more avenues for citizens to seek remedies when their rights are violated by the government.
And cruel and unusual punishments. Gerrymandering.
On punishments, at least a dozen states offer broader protections against excessive sentences, especially for juveniles, or better conditions in prisons based on their state constitutions.
Yeah.
And while the federal courts have largely backed away from policing partisan gerrymandering,
State courts are stepping in.
increasingly, yes. They're using state constitutional provisions about free elections or equal protection to review heavily gerrymandered maps.
So state constitutions have real teeth. And historically, haven't state-level trends sometimes bubbled up to influence federal law?
Absolutely. Think about marriage equality that started in state courts. The right to a lawyer if you can't afford one, Gideon v. Wainwright, built on state practices. Abolishing poll taxes gained momentum in the states first. State courts and constitutions have often been incubators for rights expansions.
Okay, so wrapping this all up. This past Supreme Court term really feels like a landmark. A consolidated conservative majority making significant changes.
Definitely. We're seeing a clear direction, strengthening certain aspects of executive power while reining in administrative agencies, returning some contentious social issues firmly to the states, and reshaping the landscape for presidential accountability.
It's a court that's actively redrawing lines between branches of government and between federal and state authority.
And doing so based on particular readings of history, tradition, and constitutional structure that emphasize limited federal government and, in many areas, deference to democratic processes outside the courtroom.
Which leaves us with a final thought, maybe something for you, our listeners, to chew on. As the U.S. Supreme Court continues on its current path, are these state courts and state constitutions going to become even more important?
Could they become the primary battlegrounds for defining and defending certain rights? What does that mean for the future? Will we see an even more pronounced patchwork of rights and regulations depending on where you live?
It certainly suggests that understanding your state constitution and how your state courts interpret it might become just as crucial as following the rulings from Washington, D.C.
It's a dynamic system, and the action isn't just in one place. It really underscores the importance of paying attention to developments at all levels of our legal system.
Indeed. Lots to keep watching. We hope this deep dive helped you navigate these complex but vital shifts. Thanks for joining us.